Losing a loved one is one of the most difficult experiences we go through in life. In the midst of grief, the last thing you want to deal with is a complex legal system. Yet many families are faced with exactly that, a process known as probate.
Probate can feel overwhelming, but it doesn't have to be. Our goal today is to provide you with a clear, step-by-step guide to help you understand how probate works. Please remember, this video is for informational purposes only and is not a substitute for professional legal advice.
When a loved one passes away, you might hear the word probate frequently, but what exactly is it? Simply put, probate is the formal legal process of administering a deceased person's estate and settling their worldly affairs.
The process serves several critical functions. First, the probate court evaluates and validates the will, ensuring it is legally binding. Then, it formally authorizes an executor to identify and gather all of the deceased person's assets, from property to bank accounts.
Once the assets are accounted for, the estate's liabilities must be addressed. Probate involves notifying creditors and using the gathered estate funds to pay off any outstanding debts and taxes. Finally, after all debts are settled, the court oversees the distribution of the remaining assets to the rightful heirs or beneficiaries. Ultimately, the court ensures that final wishes are carried out properly.
A common question grieving families ask is whether probate is always required. The short answer is no. Not all assets have to go through this complex, time-consuming legal process. In fact, many estates are designed specifically to bypass it altogether.
Certain types of assets automatically transfer to surviving co-owners or beneficiaries, completely avoiding probate court. For example, property owned jointly with a right of survivorship passes directly to the surviving owner. Similarly, assets like life insurance policies, retirement accounts, and payable on death bank accounts go straight to the named beneficiaries.
Another powerful tool to skip the probate process is a living trust. Any real estate, bank accounts, or personal property held within a properly funded living trust can be distributed privately and immediately to heirs, saving both time and court fees. Finally, even if some assets are left out of a trust or lack a designated beneficiary, your family might still avoid full probate if the total value of those assets falls below a certain threshold. Every state sets its own limit for what qualifies as a small estate. For instance, in California, families can use a simplified process if the estate's total value is under $184,500.
The probate journey begins by formally filing a petition with the local probate court in the county where the deceased lived. Usually, the person named as executor in the will, or an administrator if there is no will, takes this crucial first step. They must submit the original last will and testament, alongside a certified copy of the death certificate, to officially open the probate case and start the legal clock. Once filed, the court must meticulously verify that the will is authentic, properly executed, and legally binding. This process might involve contacting the original witnesses who signed the document to confirm their testimony. During this critical stage, interested parties also have the opportunity to formally contest the will if they suspect foul play, such as fraud, lack of mental capacity, or undue influence by another party. After the will is validated, the court officially appoints the personal representative to manage the estate. This executor or administrator is granted the legal authority to act on behalf of the deceased. They are bound by a strict fiduciary duty to act in the best interests of the beneficiaries, and the court may require them to post a surety bond to protect the estate's assets against mismanagement. The newly appointed representative must actively notify any creditors that the estate is now in probate. This typically involves publishing a formal public notice in a local newspaper and sending certified mail to known lenders. Creditors are then given a legally defined deadline to file their claims for any outstanding debts owed by the deceased. Next comes the intensive task of locating, cataloging, and valuing everything the deceased owned. The personal representative compiles an estate inventory that covers real estate, bank accounts, and personal belongings. For complex or high-value items, like commercial property or fine art, they often hire professional appraisers to determine accurate, fair market values. Before anyone inherits a single dime, the estate must settle its own financial obligations. The representative uses the estate's liquid funds to pay all valid creditor claims, final income taxes, estate taxes, and administrative costs like court and attorney fees. These vital payments must follow a strict legal order of priority, ensuring that secured debts and government taxes are fully handled before any unsecured claims are addressed. Only after all debts, taxes, and final expenses are paid can the remaining assets be distributed to the rightful heirs and beneficiaries. The representative usually provides a final accounting to the court to prove everything was handled correctly. Upon receiving their inheritance, beneficiaries are typically required to sign a formal receipt of distribution. The final step of the probate journey is officially closing the estate. The personal representative files a final petition with the probate judge, confirming that all debts have been satisfied and assets distributed. Once the judge approves the petition, the court officially discharges the representative from their duties, bringing the legal process to an end. Two of the most common questions families ask when facing probate are, how long will this take, and how much is it going to cost? The truth is, there is no single answer, as both depend heavily on the specifics of the estate. The probate process typically takes anywhere from 9 months to a year and a half. However, this timeline can stretch significantly due to factors like the complexity of the assets, disputes among beneficiaries, or simply a backlog in the local court system. As for the financial side, probate is rarely cheap. You need to account for court filing costs, fees for the personal representative, appraisals for property, bond premiums, and accounting fees. But the largest expense usually comes down to attorney fees. When you add all these expenses together, probate generally costs between 3 to 7% of the total gross value of the estate. For a $500,000 estate, that means $15,000 to $35,000 could be lost to the process. While probate is a standard legal procedure, many families prefer to avoid its time and expense. One of the most effective strategies is establishing a living trust. By transferring your assets into a trust, they bypass the probate court entirely and go directly to your designated beneficiaries. Another simple method is joint ownership with rights of survivorship. If one owner passes away, the property automatically transfers to the surviving owner. For financial accounts, utilizing payable on death or transfer on death designations ensures your funds transfer immediately without court intervention.
Finally, strategic gifting while you are still alive can reduce the size of your estate, further minimizing probate complications. Proactive planning today can save your grieving family significant stress tomorrow.
Navigating the probate process can feel overwhelming, especially while grieving. But understanding the basic steps can truly help ease the burden. Because every estate is different and laws vary by state, we highly recommend seeking professional legal advice. Thank you so much for watching. If you found this video helpful, please like, subscribe, and leave a comment below. For more resources and an easy way to find your local probate court, visit probateus.com. Take care.